Who inherits when a spouse dies without a will? This talks about the proper heirs when a spouse dies without a will. There is a famous saying that life is uncertain, but death is certain. Death is indeed inevitable and often comes as a surprise. For this reason, it is difficult to prepare for the death of a loved one. If a spouse dies without a will, who will be the heirs? In the absence of a will, legal or intestate succession takes place. In default of testamentary heirs, the Civil Code of the Philippines law vests the inheritance in the legitimate and illegitimate relatives of the deceased, in the surviving spouse, and in the state. The rightful heirs will depend on who survived the decedent. The following are the possible permutations determined under Philippine law. First, if only the surviving spouse is left, then he gets everything. Second, if the surviving spouse and legitimate children are left, the estate is divided equally among the children and the widow or widower. Third, if the widow or widower, legitimate children, and illegitimate children are left, the widow or widower and the legitimate children each get equal shares, while the illegitimate child will get a share equivalent to half of the share of a legitimate child. Fourth, if the surviving spouse and illegitimate children are left, the illegitimate children will get half of the estate, while the remaining half will go to the widow or widower. Fifth, if the widow or widower and parents of the decedent are left, the widow or widower shall get half, while the remaining half goes to the decedent's parents. Sixth, if the widow or widower, the parents of the decedent, and illegitimate children are left, the parents shall get 1/2 the estate. The widow or widower gets 1/4, while the illegitimate children also get the remaining 1/4 of the estate of the decedent. This is how property is divided among the heirs if one of the spouses die without a will under the Civil Code of the Philippines.